All right, everybody. So we're gonna continue with the B101, Article 8, claims and disputes. And the last time we spoke about the copyrights sections in Article 7. Um, Now we're gonna get into Article 8. Article 8, I would pay close attention uh, for people that are taking the practice management and the project management exams. There is a little bit of that on the construction evaluation exam. I don't think it will be a whole lot, but mostly when it comes to what to do when there's claims and disputes. So but the B101 is more focused on that project management, practice management. Um, I guess also construction evaluation, as I said, there is a lot of that happens actually during construction. Everybody can see the screen okay? Hello?
Yep,
Yeah?
it looks
Okay,
good.
perfect. So I'm going to go through that now. So Article 8, claims and disputes. 8.1 general. So 8.1.1, the owner and architect shall commence all claims and causes of action against the other and arising out of or related to this agreement, whether in contract, court, or otherwise in accordance with the requirements of the binding dispute resolution method selected in this agreement and within the period specified by applicable law, but in any case no more than 10 years after the date of substantial completion of the work, the owner and architect waive all claims and causes of action not commenced in accordance with this section 8.1.1. So this section 8.1.1 is really stating the scope of the I guess for how long of the breach, like for how long could you be covered, under what circumstances will you be covered, and what's the dispute resolution method that's being used. So contracts can be actually something that I tell you, hey, tomorrow I'm gonna go by your house and pick you up, and you hear it and say yes, okay, I will be there waiting for you. That's a contract. Can we enforce it? Maybe, but if it's in writing, it could be enforced. So basically, every day as we text and talk to people, we are creating contracts, um, and that's what it says here. Like whether in contract, right? Contract is again, you know, is an agreement from one party to do something for the other party, and the other party is probably gonna give something in return. Tort is another type of agreement. I don't know much about that, but Mr. Mike Hanahan does explain it a lot better on his lectures. He's a lawyer and an architect, so he does get more into the detail. But the reason why I'm saying that to you is because in a court of law, it's very, very, very hard to support a contract that was done by means of nonverbal communication. No, it's not written. There's no record. You want contracts to always be done in writing. And then there is a limit to that liability on the contract in here that says no more than 10 years after substantial completion. So this is that word substantial completion is going to keep coming on and on, because after 10 years of substantial completion, you're off the hook. That's why architects should be keeping record for at least up to 10 years. Now, it also depends on the statute of limitation of the particular location in which you're working. And that's what they're saying. It should not be more than the 10 years after substantial completion. But it also depends on the location in which you are. And here is also saying that we got to follow the dispute resolution method that's selected in this agreement. Dispute resolution is method is the way in which we will resolve the matter. And in here, there are a few that we're going to talk more in detail later, but I'm just taking the liberty of speaking about them now. And they could be something like mediation, arbitration, or litigation, or sort of a combination of some of those. Um, I'm sorry about that. So it will be a combination of some of those. So, um, and again, it's a way by which we're gonna resolve the matter, and it's saying that we have to kind of like they have to let each other know, and those claims should commence again within the timeline of the project. Section 8.1.2, to the extent damages are covered by property insurance, The owner and architect waive all rights against each other and against the contractors, consultants, agents, and employees of the other for damages, except such rights as they may have to the proceeds of insurance as set forth in AIA document 8201 2017, general conditions of the contract for construction. Now, a whole mouthful, but this part is just saying that, hey, let's say at Village you have insurance, and you hit a post on my property. My property has property insurance. Go to your car, deal with your claim on your car insurance, and I'll deal with the property damage on my own property insurance, and we're fine. We don't have to go against each other. We don't have to be suing each other for that. It's already covered by insurance. And that's just a general example, but there's these other things in which one insurance will cover both of them, so you don't have to, it's like, well, my insurance will cover that, so don't worry about it. So it's in the spirit of like being helpful to each other, and knowing that if something is covered, why would you want to sue the other party for damages when it's already being covered? So the owner or the architect, as appropriate, shall require the contractor, consultants, agents, and employees of any of them similar waivers in favor of the other party enumerated therein herein. So it's the same thing, saying if you have insurance, don't go after me. And then they talk more about insurances in the A201 for the construction part. Insurances are really, really important. That's actually a requirement for a lot of projects, and you will see that on the practice management exam, where if you don't have the coverages that you need, you won't be able to participate or get the projects. So that's really important. So section 8.1.3, the architect and owner waive consequence damages for claims, disputes, or other matters and questions arising out of or relating to this agreement. By the way, consequence damages, I have explained them before in other videos, but it's the fact that something caused something, and that damage that was caused has other damages beyond that point. So here we actually the architect will waive and the owner will waive that right. So what it means is, so there is consequential damages and liquidated damages. Consequential damages they're different, but I'm gonna use them in a similar scenario. So let's say our drawings were to be done by April. Because there was a storm and computers broke at our office in March, we weren't able to finish the drawings by April. The owner needed to open that store, let's say, by April. They couldn't open that store. And the costs, the holding costs, and insurance costs and mortgage costs of that property not being used in April and extending into May are $100,000. So the first thing is, it wasn't our fault that we couldn't finish the drawings, right? There was a force majeure, they call it, or an act of God, which is like a storm or whatever. um you know but because we've also signed this waiver, we are not liable for the consequences damages of the fact that we didn't actually, that project wasn't completed on time. Does it make sense? It's not just the damage of the drawings not being done, it's the damage of him not earning the money that he was supposed to be or anticipated to be earning during the opening of that particular location, and the cause of the holding cost of having to, it's actually costing him more money to open up later, right? So that's a consequence of damage. Another consequence of damage is something like, let's say I'm walking on a sidewalk, I fall, I break my leg, you know, well, I get my leg, I go my insurance covers it, the workers' compensation insurance covers it, I get my leg fixed. Later on, because I couldn't work because of that, it's been months and many months, and then those are the consequences of that fall. And then maybe 100 years later, I actually have to walk on, be on a wheelchair because of that. So this waiver says, well, no, I'm not paying you for life for this damage. You just broke your leg, the leg was fixed, you got it, you got a casket, you're good to go, you're done. The consequences of that damage and your rent and all that stuff, it has nothing to do with us. So here is just saying we're not gonna even go through it. It's waived. You don't sue me, I don't sue you, there's no consequence of damages. Okay. So this mutual waiver is applicable without limitation to all consequence of damages due to either party's termination of this agreement, except as specifically provided in section 9.7. So again, that's that. Everybody clear on that section? And my examples are kind of trying to hit the strike zone so that it illustrates the problem. There may be better examples for sure out there. But these ones I don't have, like, these are, I'm just coming up with them on the spot right now with you. So section 8.2, mediation. Mediation, by the way, is the first method of dispute resolution. And just on my own experience, I've gone through mediation in my life, and I have had to sit down, and there's my attorney, there is this other party's attorneys, and then there is the mediator. And the mediator, in my case, the mediator was talking on a spirit of friendliness. There is mediation where you don't have your attorney with you, and the other party doesn't have the attorney with them, and we just have the mediator. But in this case, we all have attorneys. It was like game on. Everybody had attorneys. So the mediator was just very talking on a spirit of. So they were kind of cultivating a spirit of friendliness, of contribution, of agreement, of peacemaking, of fairness, being fair to everybody. That mediator is being paid by me and by the other party too. So we were both paying on this end. So we don't, they're not biased to anybody. So that's that method. And as opposed to, let's say, arbitration or litigation, which we're gonna get into more detail now. But because I have experience that I wanted to tell you, and at the end of that, they come up to conclusions, or we come up to conclusions basically as a team. And if we're happy with them, we proceed, we sign them, and then we go to court. And in court, that agreement becomes valid. It isn't really valid until a judge has kind of approved it, because it makes it into law, basically. Um, so any claim, dispute, or other matter in question arising out of or related to this agreement shall be subject to mediation as a condition preceding to binding dispute resolution. This is the first step into how to resolve a problem. It's almost like mom and dad were arguing, and they went to their pastor or a therapist, and they talked to each other, and they resolved the problem. The therapist is not the law. The pastor is not the law. It could be your mom-in-law. It could be anybody. It could be a friend that simply try to settle the matter and understand that nobody has zero on the blame sort of end of things, right? Everybody has a reason. Everybody has a little bit of the dirt on the problem. So it's not 100% me, 100% you. It's not 100% you means 100% me. It's kind of like there. And this type of people help us resolve the problem. And it's prior, in this case, in this contract, is prior to going to any binding dispute resolution. Binding is something that really is a law. You can sue somebody because they breached that binding dispute resolution. It actually goes through it's much more expensive of a process and intensive of a process. This one is a little bit less. I mean, because almost anybody on the outside of construction could do it. But this in construction, by the way, is not just anybody. No, it is appointed in here, and they explain the process. It's done by the American Institute of Arbitrators, I think it is, and it's people that know about construction. There are mediators out there for marriage issues or other types of issues, but this mediator in this particular case is somebody that knows about construction, architecture, and engineering and things like that. And this is the first step. You don't go to arbitration or litigation until you've already done this step. If such matters relates to or is the subject of a lien arising out of the architect's services, the architect may proceed in accordance with applicable law to comply with the lien notice or filing deadlines prior to resolution of the matter by mediation or binding dispute resolution. So a lien is a thing, it's a hold that we put onto a parcel, land, house, property. They also call it mechanic lien, and it's something that helps us get paid. If this client was to either ever want to sell these, and the mortgages are trying to come in and pay people and resolve the thing, the title has a lien. It cannot move on to the next owner until that lien has been cleared. And to clear that lien, they have to pay the party that has put the lien onto the property. We as architects offer services related to properties for which we are able to file a lien should we not be getting paid um, for the project, for the work done. I have never had to file a lien. I almost want to do it for just to see what the process is like, but I haven't had to do it. I haven't needed to do it, and neither is something that interests me. But again, maybe the next time I talk to you, I would have already filed a lien so that we know how what the process is like. Um, but you have to prove that the person breached the contract, didn't pay you, and it has to do with payment on the property project on the property. And again, it says if such matters relate to or is the subject of a lien arising out of the architect services, the architect may proceed in accordance with applicable law to comply with the lien notice or filing deadlines. You cannot just file a lien 20 years after the problem happened. You have a timeline for when you got to file for a lien, and it all depends on the statute of limitations and the law of the place in which you live, the jurisdiction where you are working. Like say Massachusetts has its own filing. I think it's about 60 days or so, or 90 days. If you don't do it within the 90 days of the issue giving rise to the problem, you cannot do it. And then prior to that, you can either go through small claims, and then if it's less than the amounts, you can do small claims. If it's more than the amounts, they have a limit of amounts and costs. You got to go through another process. And there's deadlines. So you can do that prior to mediation so that you don't lose the right to actually doing it. You can't just like, oh, I'm not gonna file a lien because we're gonna go to mediation. It's gonna go great. No, 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 no. That's your bargaining power. That's your power right there. Your leverage, because you have a lien when you go to mediation. They want that lien over. They want that lien out of the project. So for them to get that, they want to come out of that mediation with an agreement. So that's something that you would do. Section 8.2.2, the owner and the architect shall endeavor to resolve claims, disputes, and other matters in question between them by mediation, which, unless the parties mutually agree otherwise, shall be administered by the American Arbitration Association in accordance with its construction industry mediation procedures in effect on the date of this agreement. Again, it's not just another like a random attorney that you hire or anything like that. For construction, it's a mediator. If you're following the AIA contract, which you should on this for these exams, right? That's what we're doing. It will be done by the Construction Industry Mediation, American Arbitration Association, and the procedures that they do. And by the way, when I said at the beginning that Section 8 relates a lot more to project management and practice management, is because it's about your contract with the owner, not necessarily like directly with the owner, not necessarily involving the contractor. Although there is an overlap because in the 8201, you have to do things that have to do with your contract with the owner, and the contractor is involved. But you will see that the claims and disputes here are owner and architect. That's kind of what they're talking about, because contractors haven't been coming into it yet. It's in the 8201 that we really get all the way through with the construction. Okay. A request for mediation shall be made in writing. By the way, this is very important, the steps for applying for mediation. So a request for mediation shall be made in writing, delivered to the other party to this agreement, and filed with the person or entity administering the mediation. So you gotta let the party know. You can't just be filing for mediation with somebody that doesn't know anything. They gotta know that they got it. So you can either do it by certified mail or being served by somebody that literally hands it over to them and things like that, and they sign and it's notarized. So the request may be made concurrently with the filing of a complaint or other appropriate demand for binding dispute resolution, but in such event, mediation shall proceed in advance of binding dispute resolution proceedings. Um, you could it can all be done again. Um, so it's saying the request may be done concurrently. Concurrently means it can be done at the same time as you're filing for, like, say, arbitration, right? You could file for both of them to save time, and you already have an arbitrator ready, or litigation process ready. but you cannot do arbitration before you've already done mediation. It's in order. You have to follow that order, okay? So in such event, mediation shall proceed in advance of binding dispute resolution. It's first is mediation, then any other binding dispute resolution proceedings, which shall be stayed pending mediation for a period of 60 days from the date of filing, unless it's stayed for a longer period by agreement of these parties or court order. If an arbitration proceeding stayed pursuant to this section, the parties may nonetheless proceed to the selection of arbitrators and agree upon a schedule for later proceedings. There's a process to this, so you don't do one and the other at the same time. You can file for one, but you can't be meeting for arbitration before you've already met with mediation. And I want you guys to look more into it. I know these terms are all sort of new stuff to you. It was to me when I first started taking the exams. Look up what mediation is. Go on YouTube, learn what mediation is, how mediation works. I will give you a snippet of it, but you got to augment it with more knowledge beyond what I've given you. Arbitration, right? The same thing. And again, like I said, you first do mediation, then you do binding dispute resolution. Mediation is a non-binding dispute resolution. What it means is that out of the mediation meeting, you don't have to like it. You don't have to agree to it. You can actually walk out and says, I don't like it. I don't care. I'm not doing this. Period. That's it. I went through mediation, and after we put in practice what we were talking about on mediation, it turns out to be a nightmare. Because at the mediation meeting, we're trying to come up with scenarios as to how to make things work. But when you actually experience it, it may not work. You're like, no, 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 no. That doesn't work for me. We're not doing that. We're going to stop it. And then you go to arbitration or you go back to mediation because there's new knowledge that has come into it. Um, you could go back to mediation. You just can't go back to mediation after you've already gone through arbitration. Make sense? So section 8.2.3, the parties shall share the mediator's fee and filing fees equally. Yeah, that sucks. I had to pay, I think it was $600 because it was like an hour. I know it was like 2 or 3 hours. So I paid 600. The other party paid 600. I feel it was the worst. I thought it was the best expense of my life until we realized that what came out of it was not gonna be obeyed by all parties. So like I'm a good kid. I want to do exactly what the mediator said. We agreed on it. I expressed my concerns. I want to go ahead with it. But the other party doesn't really want to go ahead with it. And there are things I didn't like about it either. So I was like, nope, I don't like it either. So we're gonna go. We may go back to mediation and then resolve the problem again. I actually at some point just get tired of the mediation because it's playing with my time and my money if you're not really gonna obey by the law, but not by the law because it's not a law. That's the issue. Like there's no punishment for you not following through with a agreement on mediation. There's literally no punishment other than the fact that you wasted your money and you wasted your time. That's it. So I like binding things, meaning if you don't do it, I'm gonna sue you. I'm gonna win, and you're gonna have to pay me. Um, like that pressures people a lot more. Now, mediation is really good when people really want to come to an agreement. They really want to be friends afterwards. Even not friends, I'm not saying you're gonna go out and get a drink, but I'm saying that if you see each other, you don't want to punch each other in the face in the streets. You know what I mean? Like you actually don't have a problem with that person anymore. It's over. We resolved it. It's fine. You might not smile at them, but you might not, punch them in the face either. So the mediation shall be held, and sorry, I don't promote aggression in any way, shape, or form. I don't like that, but I'm just trying to illustrate the matter here. The mediation shall be held in a place where the project's located, unless another location is mutually agreed upon. Agreements reached in mediation shall be enforceable as settlement agreements in any court having jurisdiction. Now, that's the part. The fact that you walked out of a place with a mediation agreement doesn't necessarily mean you got to follow through with it. If after that agreement has been signed and sealed and goes through court and it's enforced by a judge, it is, there are consequences to that agreement at that point. All right. So But from the time you get the agreement to the time you go to court, there may be some wiggle room, and that's what I'm talking about that I spoke about before, where you're like testing the grounds. Because as soon as you walked out of there, attorneys write the agreement, they send it over, you sign it. But you may sign it. Everybody may sign it, but if the judge hasn't seen it and has a, you raise your hand and you have signed these and you have not been drinking and you have not been forced to sign these, they ask you all these questions about it. I know a little too much about it, but that's when you actually, like, after the judge signs it, then there are consequences. You can be found on contempt of court for violating that order because it becomes a court order. All right, that's the thing. um and court orders, like, you may have, be found on contempt. You may do jail time for that. You may be fined for that. That's what happens after that. Again, the mediation itself is not non-binding. What comes out of that agreement that then goes through court and gets approved by a judge in front of you and the other parties, that's binding. You got to do it. Section 8.2.4 says if the parties do not resolve a dispute through mediation pursuant to the section 8.2, the method of binding dispute resolution shall be the following. Got to pick one of the two, not the two. You got to pick one or the other. One or the other. Okay. Can you do arbitration and litigation at the same time? No,
You can.
no. It's either one or the other. Okay. Arbitration is not done by a judge. It's done by an arbitrator in accordance to what we're gonna read on section 8.3. Litigation, you are going to trial, my friend. That's what litigation means. You're going to court. It's a lawsuit type of scenario. You're gonna bring you defendant. You're gonna be a defendant. Somebody's gonna be a defendant. Somebody's gonna be a plaintiff. Somebody's gonna bring their own arguments. They're gonna have their own opening speech. They're gonna have their own closing remarks. They're gonna the whole shenanigans that we see in movies. That's what litigation is. Okay. An example of litigation is actually a divorce proceeding. Is a litigation matter where people make an argument for what they have, what they don't have. They bring everything. Judge looks at it. Um, if there is other type of litigation, which is like the criminal litigation, where is you may have a bench trial or a jury trial. Bench trial is just the judge listening, and the judge makes the determination at the end of it. You don't have to like it. You have to obey by it. If you have a jury trial, the jury is the one that will either find you guilty or not guilty, and it has to be done beyond any reasonable doubt. Right? You got to be found guilty beyond any reasonable doubt by everybody. They all have to unanimously agree. If they don't agree, then you're not guilty. I actually participated on a trial in Boston at the district court as soon as I became a citizen of the United States. That was like my welcoming to the United States thing, and it was pretty fun. It's scary fun. It's scary because you don't want to mess with the law. You don't want to do anything wrong ever, and you don't want to be doing anything wrong that you don't know or you're not like sure about. So when in doubt, you gotta call an attorney and make sure things are clean. Don't do anything that you're not sure about. Again, I'm not trying to also give people advice as to how to proceed with their lives. I'm not a lawyer, but I'm just giving you my opinion on these things. If the owner and architect do not select a method of binding dispute resolution or do not subsequently agree in writing to a binding dispute resolution method other than litigation, the dispute will be resolved in a court of competent jurisdiction. If you didn't pick anything, it will be picked for you, basically. Okay, so 8.3, arbitration. If the parties have selected arbitration as a method of binding dispute resolution in this agreement, any claim, dispute, or other matter in question arising out of or related to this agreement, subject to but not resolved by mediation, shall be subject to arbitration, which is, unless parties mutually agree otherwise, shall be administered by the American Arbitration Association in accordance with its construction industry arbitration rules in effect on the date of this agreement. A demand for arbitration shall be made in writing, delivered to the other party to this agreement, and filed with the person or entity administering the arbitration. Then we go to section 8.3.1. By the way, after the section 8.3.3, I'm gonna pause for a minute and continue with the consolidation and joinder I'm just gonna take a quick break. So again, on 8.3.1.1, a demand for arbitration shall be made no earlier than concurrently with filing for the request for mediation. Meaning you can't file for arbitration first. You can either do it together or after mediation. Okay? With mediation or after mediation. And again, it does say, but in not event shall it be later made after the date where when the institution of legal or equitable proceedings based on the claim, dispute, or other matter in question will be barred by the applicable statute of limitation. It always saying, hey, you remember how we spoke about 10 years? There's a 10 years clause all the way at the beginning of Section 8. So 10 years is kind of what the AIA puts as a limit. But the statute of limitation may say 8 or 5. The statute of limitation varies depending on, this is my opinion though, I'm not a lawyer, but it does vary depending on the case, depending on the matter. And like something may have 3 years, something may have 4 years, and after those 4 years you cannot sue me, you cannot go after me, you cannot do anything, you know. Nothing is really perpetual. As you know, the world changes every single day, so nothing is really, I mean, forever. So they can't just come after you after like 20 years. Like, why? Why on earth? So, and that's what he's saying in here. It cannot be done after that. For statute of limitation purposes, receipt of a written demand for arbitration by the person or entity administering the arbitration shall constitute the institution of legal or equitable proceedings based on the claim, dispute, or what he's saying is the day that was put, that the arbitration notice was put in there, that's my clock. That's ticking right there. That's ticking. And it's equivalable to any other proceeding. So it's already taking effect. Section 8.3.2, the foregoing agreement to arbitrate and other agreements to arbitrate with an additional person or entity duly consented to by the parties to this agreement shall be specifically enforceable in accordance with applicable law in any court having jurisdiction thereof. It's saying you can add other people within it, and there may be other kind of other people on the situation, not just like you and the client. There may be other, and I don't quite understand this a whole 100%, but that's what I get from that. The award rendered by the arbitrator shall be final, and judgment may be entered upon it accordance with applicable law in any court having jurisdiction. That award, that arbitration is done, that's final. It's not the same as mediation. Remember mediation? You may like it, you may not like it. If it's not signed by a judge, it's not a court, you don't care. This one is done. This one is a done deal. And you can't just back out. You're done. It's over. So on that note, I'm gonna pause it in here for a minute and we'll continue later. So resuming back, so we finished 8.3.3. We're gonna go to 8.3.4, consolidation or joinder. You guys have heard of the word consolidation credit or anything like that? Where like they grab all your debt and make it into one debt, basically. Anybody? Yes? No? Maybe?
No, haven't heard of that.
Well, if you watch the TV, there's all this like we can consolidate your credit repair, blah blah blah. So
Oh.
they basically grab all your credit cards, pay them off, and put them into their financial institution as one debt, like one big loan, and you just pay that one. What's the benefit of it? Well, you just paying everything on one place, and you know what you owe, and you're not paying multiple rates. You're just paying one rate for the whole loan because one credit card may be 10%, another one may be 5, another one may be 2, another one may be 3. I did it myself on my own. Like I have one small credit card. Again, it's just me things I've done, not financial. I'm not a financial institution and advisor, but I put like I had a credit card that was like 3% interest, I think, like very low, and then I had another one that was like 20% interest and another one that was like 10, 15. And I wrapped all of those and paid them off with the one that was like 3% interest. So technically I was saving money by doing that. And I put it into one place. I'm going to relate it to 8.3.4. Doesn't mean I'm not paying my debt. I'm paying the same amount of money. I'm just not paying the same amount of interest on that total amount. Consolidation or joinder prior to me explaining it here on the actual content, is when you consolidate claims that are similar, you know, debts that are similar, right? Things that are similar. You put them into one place and you pay them off together. Like deal with them together. If they're equitable, similar, what's the word? Compatible, right? So I'm gonna read it now and you're gonna understand it better. 8.3.4.1, either party at its sole discretion may consolidate an arbitration conducted under this agreement with any other arbitration to which it is a party, provided that one, the arbitration agreement governing the other arbitration permits consolidation. Two, the arbitrations to be consolidated substantially involve common questions of law or fact. And three, the arbitration employ materially similar procedural rules and methods for selecting the arbitrator. It may be a case in which you have a claim against the owner and the owner has a claim against you, and then the owner has a claim against the contractor and the contractor has a claim against you, and they're all about the same project. They're all within the same circumstances. It may all be about the roof leaking or something going on in there. You can all, instead of you having a claim arbitrated with the contractor and the owner having a claim arbitrated with you and the owner having a claim arbitrated with the contractor, you put it all together into one claim, and you don't have to be going to a million meetings and a million procedures. You're going to like one big procedure that then is gonna determine the outcome of all of you within your claims. Does it make sense? And again, the rules for that to actually happen, or the guidelines is the arbitration agreements gotta allow it, that you can consolidate them. They also have to be common questions of law, not like wasting time. They're not related at all. It's a waste of time. You know, and the arbitrations employ, it's the same procedure. It will be a similar procedure. So like the arbitrator will be very familiar with the whole case after this situation because they will know almost everything about the case. So why have two arbitrators and then have to fill in one about the subject and another one about the subject and pay both of them? The costs might be close to each other, but I can see them being substantially less if you consolidate it, because all of you are gonna pay together, pitch in. So that's one thing. So section 8.3.4, does it make sense? You guys understand now what I mean? Okay, so section 8.3.4.2, either party at its sole discretion may include by joinder persons or entities substantially involved in a common question of law or fact whose presence is required if complete relief is to be accorded in arbitration, provided that the parties sought to be joined consents in writing to such joinder. They may say, nope, I don't want the architect to be involved, or nope, I don't, and that's okay. Consent to arbitration involving an additional person or entity shall not constitute consent to arbitration of any claim, dispute, or other matter in question not described in the written consent. Then we go to section 8.3.4.3. The owner and architect grant to any person or entity made a party to an arbitration conducted under this section 8.3, whether by joinder or consolidation, the same rights of joinder and consolidation as the owner and architect under this agreement. And then it says, the provision of the Article A shall survive the termination of this agreement. And then we go to termination. Can we actually finish it? That's Article 9. Let's see if we can do that. Article 9. You know what? No, we're gonna leave it at this, guys. If you don't mind. I think that the Article 9 will take a chunk of time. Termination is pretty big. And we're gonna just continue on the next one on Article 9 and hopefully finish all of the other ones. Sorry, I just saw it and I think that I want to take my time on Article 9 on how termination happens, when it happens, and how do you go about it. All right? Is that okay with you? Everybody? Yes? No? All good. And I'm gonna upload this. I'm gonna upload this right now. We'll stay in touch. Okay.
All right.
Thank you, guys. Bye bye.
Thank you.